嗨，曲老师，
江宇你好，
兰杰，
哎，江宇你好，
你看到露出头这个呢，是我的同事，我的前同事曲震老师。
曲老师好。
您好，兰女士，
你好。
他过去在恒大，然后他去年退休了，回澳大利亚了，现在在澳大利亚新英格兰大学 New England。
欢迎。
OK， 嗨。
对，然后那位女士呢是我的同事，温慧仪教授 Professor Wang Waiyi。
温教授好。
你们二位也看到了，是今天的主讲者兰杰，兰大律师还有刚刚加入的呢是林玉新老师林玉新老师也是
林老师。
对，林玉新老师是来自台湾的，但是对大陆的公司法非常非常的熟悉，我经常指导我。
没有，不敢，我都跟王老师学习。
你们俩都在谦虚。
好，玉新，这是那个今天我们的主讲人兰杰大律师
你好。
我们可以等2-3分钟，因为其中有不少人应该算是我的学生，这些学生们总是要迟到的，我看样子。More of them are coming, so good.一会儿我介绍完了之后，你就可以自己去 share screen。
好的。现在的课还都是网课为主吗？香港大学的？
已经不是了。我这个课其实原来是就是本来就是见面讲的了。但是因为今天是你来讲嘛，你也来不了，所以就只好是网课了。一半。
一半。
一半一半。就是说因为有来不了的学生就可以远程，但是总有1多半的学生来的。I think we can roughly start. Welcome everyone to this seminar, and this is actually we have recently launched the Chinese Law and Practice seminar series at the Center for Chinese and Comparative Law of the School of Law of City University of Hong Kong. The purpose of the seminar series is to serve as a bridge between law and practice, of course, with the broader purpose to promote the study of Chinese law from a comparative perspective. So the lecture today, the seminar today given by Ms. Lan Jie is actually the first one of our seminar series. More will come. For those who are lawyers, right, in Hong Kong and in the mainland China, Ms. Lan Jie doesn't need much introduction. She is one of the top lawyers on corporate law and capital regulation and securities regulation and capital market. She was educated in Peking University Law School with a LLB degree and master degree, and then she started in NYU School of Law, and after that she joined Cravat. That's based on what I know, that's the most elite law firm in the US with very few offices. So she practiced in New York at Wall Street, and then moved to Hong Kong, and a few years later she joined Freshfields, and so she's not new to Hong Kong. She's not alien to Hong Kong. She stayed in Hong Kong for quite a number of years, and then she went back to Beijing and is now one of the leading partners in Haiwen and Partners, which is one of China's top law firms. Ms. Lan has advised many international multinational companies and has played the role of the leading legal counsel in many major transactions. So to me, she's indeed one of the best business lawyers in China, and definitely the best female business lawyer in mainland China. And I also have to disclose that she was my classmate in the Peking University Law School. So, and in that capacity, she has been my own role model for many years. And she's now the role model for my daughter, my 13 years daughter. So we know each other as a family very well. And we are also honored to have 3 of our colleagues. So as you can see, have Dr. Charles Chu-Jin, who was with us for many years and then retired last year, retired now is doing teaching and research in Australia. And Professor Wang Waiyi, from Singapore, and also Professor Lin Yuxin. We are very lucky in this law school. We have indeed the best corporate law and securities law scholars, not only in Hong Kong, in the region, but also in the world. So they are all both first-class corporate law researchers, and I'm very proud that we have the best, not only in Hong Kong, but also in the world. And we are very honored to have such a group of distinguished panel on such a wonderful topic. So the topic is very, very, it's a cutting edge topic, and very topical, about a very topical issue. And it also fits in my class I'm teaching called the Chinese and comparative company law. So many of the students today, actually, the students of my class. So with all that, I would like Anjie to start her presentation, and after that we will have each discussant will be given 10 to 15 minutes. It's up to you. So 10 to 15 minutes to make comments, and then we can have some interactions between the speaker and the commentators, and then we'll open the floor for question and answer. We can be rather flexible today, so we can have maximum 3 hours. So I guess Ms. Lan will be talking for 1 to 1.5 hours, and then after that we can have a break if necessary, and then we enter into the question and answer session. Right. So, but we have 3 hours. We don't have to use up all the 3 hours. We can end earlier. But if the discussions can go sometimes discussion can go very dynamic, then we can. So we have enough time to go today. So with all that, please, the floor is yours, Anjie.
Thank you, Jiang Yu, for the introduction. And it's a great pleasure for me to have this opportunity here to present some of my observations from my working as a lawyer in the capital market. Indeed, Jiang Yu and I have known each other for many, many years, since we were very young, in school. And at that time, I think we both imagined that, someday Jiang Yu will become a big name lawyer, and I will become a diligent, scholar, doing research in the school. But look what has turned out to be the circumstance for both of us here. Yeah. So indeed, I think it's a reminder for the young, for the students who are still young here. Don't narrow your scope of imagination, because you are capable of, much more than you expect now. So without further ado, let me start, sharing the screen. Yes, today's topic is overseas listing of Chinese companies and also homecoming opportunities for Hong Kong. Because I'm a lawyer, so a lot of the materials is prepared from a very practical perspective. But if you have any questions or want to interrupt, just feel free to raise your hand or interrupt, or just voice out. The presentation will include these 4 major parts. The first part is path to listing for Chinese companies, an overview. Here I've listed out in a table format the different options for a China-based company to seek listing. And it depends on the place of incorporation of the issuer. It can be categorized into two large groups. And the first group is for companies that are incorporated within China, i.e. those are the typical China companies that are governed by the China corporate law. And for these companies, they have three natural choices. One is to list in Hong Kong, in which case the securities listed is referred to as H share. H refers to Hong Kong. And the Chinese company will need to get CSRC approval as well as Hong Kong regulators approval. A second option is for these companies to list in the US, and the securities that they will issue will be called N share, which N stands for New York, and also they may also issue ADRs. With respect to the regulations required in China is the same, i.e. the company needs to get the CSRC approval, and overseas it needs to pass the SEC's review. But just a note here, although this is theoretically still possible, actually this has not been seen since 2004. And what happened in 2004 was that China Life, shortly after it listed in Hong Kong, encountered class action in China, in the United States. And ever since then, no China company has gone out to list in the States yet. And the third option is for the most natural one is for these China incorporated companies to list in the PRC in China in the Asia market. And then, the second category is for companies that are listed overseas, which are referred to as red chip companies. And again, depending on the place of listing, there are three natural choices: Hong Kong, US, and the PRC. And as you can see here, when it's listing in Hong Kong and US, no PRC regulatory approval is actually needed. But this is the circumstance up to the day, i.e. in the past 10 or 20, 15 years, there was no PRC approval required for overseas listing by the so-called red chip companies. But things have started to change this year. And the PRC regulator has indicated that they will strengthen the supervision of China-based companies in their listing overseas, but the detailed rules have not come out yet. We'll talk about this further later. Here I have compiled a comparison table of some of the key points in the different markets. I think a lot of that is very important for the potential issuers and their investors to consider when they decide where to list, because many of these requirements will either affect their time to the market, i.e. how long they have to wait after they have incorporated or after they have invested in the company, and also the type of structures that are permitted. So as you can see here, I have listed Hong Kong, US, and then two columns for the Asia market, because here now in China there are two different boards in China. One is the main board, and the other, actually there are three boards: the main board, the star board, and the Chinex board. But the rules of the star board and Chinex board are quite similar in that they are both conducting piloting reformation in certain regards, and therefore allows more flexibility than that is permitted in the main board market. But as you can see here, the Asia rules require significant longer time before the company can get listed in China. So this is a very significant concern that every issuer needs to be aware of. And also, our favorite topic, VIE, it is not yet permitted in Asia main board yet. It is permitted in the star board and Chinex board, but is subject to case-to-case approval. Whereas in Hong Kong, it is permitted on a narrowly tailored basis, and in the US, it is permitted subject to disclosure. And recently, the SEC has made a lot of noises about enhancing the disclosure requirement in this regard. Let's also look at the lockup and liquidity requirements for the existing shareholders, because for a lot of investors, the purpose, especially the PE investors, the purpose of their investment in the company is to eventually seek liquidity someday. And therefore, this lockup requirement is particularly important for them. You will see here in Hong Kong, in both Hong Kong and the US, the typical lockup is about 80 days. And that is primarily driven by the negotiation with the underwriters, especially in the US. There is no statutory requirement on the lockup in the US. In Hong Kong, there is a listing rule requirement, which is still 180 days. But the situation is dramatically different here in the Asia market. In Asia market, the CSRC and the exchange rules prescribe for a very, very detailed lockup requirement. And for controlling shareholder, that requirement can be as long as 3 years, which is very, very significant. And for the other shareholders, depending on the time of their investment, it could also be 3 years, or it could be at least 12 months. So let's now move on to the second part, which is let's look at the overall process and requirements of an overseas listing by Chinese companies. So where did all the Chinese companies go in 2020? We've prepared a pie based on the status that we gathered from the market, and you can see that Hong Kong is definitely the most preferred destination for Chinese companies. I wanted to highlight here. This pie only shows the destinations of overseas listing, i.e., it did not cover the Asia listings. And for a red chip company to list overseas, it needs to be subject to domestic regulatory requirements and overseas regulatory requirements. The overseas regulatory requirement is quite straightforward. It depends on the place of listing, and you will need to pass the review of the securities regulator in the market where you seek a listing. In Hong Kong, that would be the SFC and the Hong Kong Stock Exchange, while in the US, it will primarily be the SEC, while the stock exchange may also conduct very limited review. And in China, if it's a red chip company, as I said just now, no approval from the CSRC or other regulators are required as yet. As of today, it's not yet required, provided that the setup of the red chip structure itself complies with the PRC laws, and that foreign exchange registration is duly completed by the PRC investors. And what does this mean? The setup of the red chip structure complies with the PRC law. This is because the setting up the red chip structure primarily involves an acquisition by foreign investors of a Chinese company, and therefore it is subject to the Foreign Investors Acquisition Rule, which is the famous Circular 10 or the 10号令. And what is a red chip structure? This is a very, very simplified graph showing what is a red chip structure. It basically means that a company is ultimately owned by PRC persons, and the operations is also in China. However, these PRC persons own these PRC operations via an overseas holding structure. In Chinese, we refer to this as 中外中, China overseas and then China again. And this bit is also quite often referred to as the round trip investment, 返程投资. And this is a more detailed, typical red chip structure. So here we have the founders, which are PRC persons. And then the company will have attracted several rounds of investments before its IPO exercise. So there are A round investors, B round investors, etc. And then typically, they would have also reserved a portion of the shares for a ESOP plan, which are for the employees' incentives. Here is the overseas holding structure. Typically, it will have 3 layers: Cayman, BVI, and Hong Kong, which is primarily driven by tax concerns. And then, this Hong Kong company will have a WFOE in China. By WFOE, we mean a wholly foreign-owned enterprise. And the WFOE can conduct unrestricted businesses. By unrestricted business, we refer to the businesses that are open to foreign investors with no foreign investment restrictions. So that is why it can be 100% owned by foreign investors. So this alone would have been a complete red chip structure. But in many of the red chip companies that you see in the market, there is an extra element, which is the VIE element. And what does the VIE element do is that there will be an OpCo, meaning operational company, which conducts certain restricted businesses, i.e. business that is not entirely open to foreign investments, but it's foreign investment in this regard, it's still subject to certain level of restrictions. The most famous ones, example would be the telecom industry, the ICT license, where foreign investors cannot own more than 50%. So that business can be owned and conducted by the operational company. And this OpCo is a domestic company, is purely owned by Chinese persons. And how does this OpCo link up with this whole structure? There will be a set of contracts between the OpCo and the WFOE. And that is what we call the VIE contracts. And by way of these contracts, 2 things about the OpCo are transferred to the WFOE. The first is the control over the OpCo. So the control rights are transferred to the WFOE. And the second is that essentially all profits of the OpCo will also be transferred to the WFOE. By transfer of these 2 elements, the control plus the profit, OpCo can, from an accounting perspective, be consolidated into the accounts of the WFOE and the holdco structure. And then we have a complete red chip structure with a VIE element in it. Here I've just set out a brief timeline of overseas listing in Hong Kong. It involves primarily 4 stages. Actually, this is the same everywhere in the world. In the US, it's the same 4 stages: preparation, regulatory review and approval, marketing and pricing, and then listing itself and trading. It's the same here in China too. It's just that, in different markets, the process can be longer or shorter. So in the preparation period, the Israel will engage all the professional parties, including the investment banks, the lawyers, the accountants, etc. People will conduct due diligence, prepare the draft prospectus. Where necessary, the company may also go through a reorganization to achieve a optimal structure for the listing. And then, when the prospectus is almost done, when the due diligence is completed, the team submit the A1 application document to the Hong Kong Stock Exchange. And from that point on, the Hong Kong Stock Exchange will look at the application and raise questions. And the deal team will engage in, responding to that questions, etc. Then after this review process is completed and the Hong Kong Stock Exchange is satisfied with the disclosure, there will be a hearing, after which the company is ready for marketing and then listing. So now let's move on to the third part, which is a conflict between the US and the PRC on regulations of companies listed in the US, which I think is also is a very hot topic these days. It has affected the different markets and also the policymakers in the three jurisdictions. The fundamental origin of conflict, in my view, is because of this. On the US side, the PCAOB, which is created by the Sarbanes-Oxley Act in 2002, required that auditors of the US public companies be subject to external and independent oversight. In other words, when a Chinese company, when a Chinese concept company or Chinese red chip company seek a listing in the US, it is not sufficient that the accounts of this red chip company have been subject to the audit by a US qualified accounting firm. It's not sufficient. The PCAOB also requires that accounting firm should open the books to PCAOB for external and independent oversight. But this is not possible in the not entirely not impossible, but this is not this has created an issue for Chinese red chip companies because the PRC Securities Act says that overseas securities regulatory authorities shall not carry out investigation and evidence collection directly within China. And without the consent of the securities regulatory authorities, no organization or individual may provide the documents and materials relating to the securities business activities to overseas parties arbitrarily. Which means that for a red chip company that is listed in the US, substantially all of its operations are conducted in China, and naturally, substantially all of, or at least the bulk majority of its books, financial books and underlying work papers are stored in China, and those are relating to business activities that are conducted inside China. And this rule limits, the capacity of the auditors to hand over this information to PCAOB for review and investigation. PCAOB was created in 2002, right? So this conflict has been in existence for quite a long time. It's not a new thing. Here I've summarized a short evolution of the conflicts over the past 10 years or so. Actually, in 2013, this issue came out once, and it caused quite some discussion at that point in time, but not at the same scale that we are seeing today. Because at that time, eventually the two sides, the CSRC and the US regulators were able to reach a MOU on the cooperation in enforcement of the joint investigation of the accounts. However, in the years after 2013, apparently the implementation of that MOU has not been satisfactory to the US side. And towards 2018 and 2019, we started to hear more concerns raised by the US side. And since 2019, China-based companies began to return to the PRC and Hong Kong just to be prepared. And then in 2020, President Trump signed the Holding Foreign Companies Accountable Act into law. I mean, it's called Holding Foreign Companies Accountable, but everybody knows that it's targeting the Chinese companies. And then most recently in this year, two things happened on the China side. One is that the China government issued the opinions, which is a joint opinion issued by the central, the CPC, the central office of the party, as well as the central office of the State Council, which calls for strengthened supervision over listings by Chinese companies. And also the draft security review measures was promulgated. And coincidentally, CSRC, the PRC regulators also issued new policies on the internet and education sector. I mean, this bit is not directly related to the securities regulation or the conflict that we talked about, but the impact of this policy is that the share price of a lot of quite a number of U.S. listed red chip companies tanked immediately. The most famous examples are Xinhongfang. I'm sure you've heard of that. And this sort of caused panic, in the U.S. market, and deepened the distrust towards Chinese companies, because the U.S. investors and regulators saw that the China regulators and policymakers can take actions very abruptly that affect companies that are already listed and cause a significant loss to U.S. investors. And the U.S. regulators thought that this is a risk that needs to be promptly disclosed, and they immediately signaled that they will enhance the disclosure requirement on red chip companies based in China. So that is what the chairman said on July the 30th, 2021. He stressed the necessity of full disclosure of China-related risks. So what does the Holding Foreign Companies Accountable Act say? It primarily says two things. The first thing is that it requires companies to certify that they are not owned or controlled by a foreign government, which I think, is more insulting than, harm doing to most companies, because most red chip companies would be able to certify that they are not owned or controlled by a foreign government. However, the second bit is the one that is difficult. It requires companies to open their books to PCAOB, and refusal to do so for 3 consecutive years would result in a ban and delisting. And that has already happened to a number of big SOEs, as we've seen in the market. And it's interesting to look at the response from the China side. I've summarized some of the responses as reported in the news here, but the primary message is that the China side believes that audit supervision is a matter of cooperation between governments. Therefore, the way to approach it is still to seek a discussion and cooperation. But my understanding is that the bottom line of the PRC side seems to be that while we will definitely be willing to cooperate, we would still want to retain some sort of discretion as to whether or not finally we will open the book to you. But on the US side, they think, if the process moves like this, i.e., if we need your approval, we need your green line in every case, in every investigation, it's just not going to work, because it will slow down the process and slow down the provision of documents. Recent progress in the US. SEC chairman actually posted a video on his personal Twitter, in which he said that, I've asked staff that we take a pause for now on such listings of shell company issues associated with China-based operating companies. In the lawyers' world, on that day, August 18th, this message got, spread on WeChat 朋友圈 immediately, because it's huge. It says that, listing by Chinese-based operating companies will be paused, while in reality is that it's not that bad. It's not a real pause. It's just that the SEC wants enhanced disclosure. And actually, in the deals that we are working on, there is a full set of China-related questions that every company that has a China element needs to answer. And I also understand that, previously there were primarily two work streams reviewing each IPO, being the financial work stream and the legal work stream. But nowadays, for Chinese-based companies, there is a third work stream, which is the China work stream. So which means that Chinese companies are now subject to an additional layer of review in its IPO process, and that review takes, the timing of that review is uncertain and could be prolonged. So just now we touched upon, on the China side, the fundamental concern is that we are not comfortable with handing over China-related data and information to overseas regulators. That's our fundamental concern. And previously, this concern was spelled out in the securities law, as we just looked at. It was also spelled out in this kind of Asian rules, Asian rules about archive protection, storage and management of archives of information related to overseas issuance and listing. But recently, the data security law also came into effect that adds an additional level of regulation. And then, thirdly, as I mentioned, in July, the opinions were issued by the General Office of the CPC and the General Office of the State Council. To be fair, I think the background of these opinions was primarily triggered by the Luckin scandal. But the signal that is sent in this opinion is that the PRC regulators will strengthen the supervision of China concept stocks. It's still not yet clear how this supervision will be achieved. But the good news is that, recently in several different occasions, the PRC regulators have indicated that they still support domestic and overseas enterprise to list in Hong Kong, which is good news for the Hong Kong market, and that they will keep the channels for overseas listing unblocked, i.e., it should still be possible for Chinese companies to seek listings overseas. It's just that, there will be a further level of supervision that it needs to pass through before it goes abroad. Recent cases of Chinese companies listing and delisting. We talked about the Luckin coffee scandal just now, and the result was that they agreed to pay a 180 million penalty to settle the charges. And these four companies were subject to the cybersecurity review shortly after they were listed, which caused, of course, further concerns on the U.S. side on the inherent risk of Chinese companies. And these three giants, they were delisted from NYSE and have returned to the Asia market. They are now all listed in Asia. Actually, Haiwen represented China Mobile and China Telecom this year in their listing in the Asia market. Another point to touch upon is the difficulty in cross-border enforcement. I mean, this is natural. This exists in every cross-border listings, regardless of whether the company is incorporated or have operations based in China or in other areas. As long as the company, a company that is incorporated in A country seeks a listing in B country, there will be this difficult, because naturally the decisions or the orders of the courts of B country will need to find a way for enforcement in A country, and depends on whether there is a channel between these two countries, most often in the form of a treaty of mutual recognition and enforcement of court decisions. Then there will be this risk. And therefore, this paragraph is seen in almost every red chip company prospectus. There is always a similar risk factor, notifying the investors that, well, look, you are investing in a company that is incorporated somewhere else. The assets and the directors and officers are resident in another country. So even if you win a litigation here, we may not be able to have the judgments enforced. So what does this mean for Hong Kong? Given the uncertainty with respect to the Sino-US relationship and the trend that a lot of companies are returning, are delisting from the US, and while some are still trying to seek a listing in the US, it has become significantly much more difficult than before. Therefore, it can be envisaged that a lot of the companies will consider Hong Kong again for their further capital market fundraising activities. As you can see, the companies are already returning to Hong Kong and mainland China. These companies, Alibaba, Jingdong, NetEase, etc., have already sought a secondary listing in Hong Kong, and these are seeking dual primary listings in Hong Kong. And we have also heard news about Chinese companies who were in the process of doing a US IPO and listing, but changed their plan and aborted the US listing plan and instead choose to list in Hong Kong. And some of them may also consider returning to the Asia market as well. This has been made possible by the recent Asia reformations that have made the return of the unicorns possible. Previously, companies that are incorporated outside China, i.e. companies that are not subject to the PRC company laws, cannot issue A shares and get listed in the Asian market. The entire Asia rules are not formulated for a company incorporated in another jurisdiction. But things are changing these days. First of all, red chip companies who are listed outside China can now actually list in Asia. So this is a significant breakthrough from the previous securities law. And secondly, the regulators are reforming the regulatory framework for Asia IPOs and trying to switch from a registration process to approval process to a registration process. Under the approval process, every IPO needs to be approved by the CSRC. Under the registration process, the concept is that it's all disclosure based. Once the disclosure is satisfactory, then you can go ahead with the listing as long as you seek a very short registration with the CSRC. However, that is the concept, and I think in practice, the review and the registration still looks pretty much like a regulatory approval process. And the CSRC now also allow VIE structures to be kept. This is another significant breakthrough, because previously under the Asia rules, one listing condition is that the shareholding structure needs to be clear and there is no holding in trust for other people, or there is no holding shares or assets on behalf of other people. And VIE structure is just the opposite, right? But now the CSRC allows the VIE structure to be kept in certain circumstances, although it needs to be subject to a case-by-case review process, and the industry regulators will need to be consulted as well. Relax of foreign investment restrictions also made this possible. And finally, another major reformation in the Asian market is the valuation gap, the pricing mechanism for Asia IPOs. Previously, the Asia IPO has quite stringent pricing rules, the most famous rule being the 23 times PE ratio, 23倍市盈率. Currently, that rule is still applicable to the main board, but it's no longer applicable to the star board or the Chinex board. And this return, takes place step by step. It's not yet open to all industries yet, but the CSRC is gradually expanding the scope of pilot programs. So you can see now it covers more industry than it started about 2 or 3 years ago. But still, there is a list of industries that you need to fit in. There are 3 models of return by unicorns. We'll call it the CDR model, the Asia model, and the unicorn model. The CDR model means red chip companies will issue CDRs for listing on the Asia market. This is more. I think this should be the most natural option, because as I said, red chip companies are companies that are incorporated outside China, not a PRC company, and therefore, but the securities that will be listed is China securities, right? So there is a kind of a dislink between that, and to link these 2 elements, the natural way is to look at what the US does by creating a CDR program, so that you convert the shares in the overseas company into China depository receipt and list that in the Asia market for trading by Chinese persons. And this requires an issuer and the depository. This requires a depository to come into play, and there will be a 3-party agreement between the issuer, the depository, and the investors. Of course, the investors will not be there to sign the agreement, so the depository will be acting on behalf of the investors. However, somehow, a lot of some of the companies, some of the unicorns that have now returned to Asia market has not selected the CDR approach. I think it's probably because CDR is a new concept. The liquidity is uncertain. Investors are not familiar with it, etc., etc. And some of them, and they have actually chosen the Asia route, which means that those overseas companies issue A shares directly in China. For example, let me see. I think Geely probably did that. They issued A share directly, which actually needs cooperation from a number of different authorities. For one thing, the foreign exchange is an issue, because the company is. The issuance of these securities is overseas company, but the investors will be subscribing for the shares in RMB, and therefore, how does the RMB investors pay go into the company's capital account? And when they trade, how does the foreign exchange work in between? And there is also tax issues, which I wouldn't go into any detail about here. The unicorn model is very unique. I don't think you need to pay too much attention to that. This is not a model that can be replicable. I think it was subject to a special approval. What the model achieves is that although Unicom is listed now in Asia, the listing vehicle is actually a different entity than the vehicle that is listed in Hong Kong. So there are two levels, or 2 different listing vehicles here. So what is the strength of Hong Kong compared with the Asia market? First of all, the time required for listing in Hong Kong is normally much shorter than listing in the Asia market. This is because the Hong Kong's registration system is much more established, much more mature, and with less intervention from the regulators. And the whole process is also much transparent. And no CSRC approval is needed for the time being. It is not subject to some of the very specific due diligence requirements prescribed by the Asia rules either. A CICC lead bank once said in a conference that the workload of doing an Asia IPO is about 4 times of that doing an IPO in the US or Hong Kong, which is very, very true. And I think that reflects the different style of regulation in different markets. Even though nowadays in the PRC Starboard and Chinex board, we are now also doing a so-called registration system. The registration system still operates pretty much like an approval system, and the regulators are very, very actively involved. They look at, they still make a lot of substantial judgments on the company's suitability of listing. In particular, in China, they pay a lot of attention on the compliance status of the company, whether the company has been penalized by regulators in China in the past 3 years, etc. They prescribe very detailed due diligence process and requirements for the intermediaries. For example, they require the investment bankers and the accountants and lawyers to interview suppliers and customers, and the percentage of the suppliers and customers that need to be covered by the due diligence interview is very, very high. It's like, at least 70% or something, which is something unimaginable in the US context. Therefore, the whole process involves a lot more, labor-intensive work. And the questions that you may get from the reviewers are also much more detailed and time-consuming. In terms of the listing conditions, the criteria that a company has to satisfy, Hong Kong is also more flexible. And I think we've looked at some of these points before. Shorter lockup period, which is very important for issuers and also for investors. No pricing limit. The 23 PE ratio rule is not a written rule. It's more like a window guidance, but it has been observed in main board IPOs. And even though this does not apply to Starboard and Chinex board, there are other rules that are applicable to Starboard and Chinex board IPOs. You have to consult the regulators for their window guidance from time to time. But to be fair, I have to say the overall valuation in the Asia market is still much higher, tends to be much higher than in Hong Kong or the US. Yes, and Hong Kong also offers more listing routes for an issuer to choose. That includes secondary listing and SPAC listing. But compared with the US, the advantage of Hong Kong is also quite obvious. First of all, it's less affected by the political relationship between China and US. It's not subject to the whole dispute about holding foreign companies accountable and the audit inspection, etc. Potentially, Hong Kong may be exempted from the cybersecurity review. I mean, when the cybersecurity review measures, the consultation paper was released, the market player was very quick to pick that the terms used in the rule about the cybersecurity review was that 到国外上市 instead of 到境外上市. And people interpreted in a way that 国外 means you are seeking a listing outside China, including Hong Kong. And if you are seeking a listing 国外 in a foreign country, for example, in the US, then you may need to go through this cybersecurity review. But however, if you are seeking a listing in Hong Kong, which is not another country, is not a foreign country, then it's possible that the cybersecurity review will not be applicable. But this is just the market speculation and not yet confirmed by the final rules. And also, of course, given the culture, background, etc., the business of China-based company is more easily understood by the investors in Hong Kong. And given the closer tie and cooperation, a relationship between the different markets, Hong Kong also enjoys the convenience of both international and domestic capital markets. Currently, we have Shanghai Hong Kong Stock Connect program, Shenzhen Hong Kong Stock Connect program, etc. And we'll look at the H-share full circulation point later. And also the investors in Hong Kong are much more friendlier than the U.S. Investors in the U.S. who are very litigant and very fond of initiating class actions, etc. As we mentioned, at the beginning, nowadays it's very Chinese incorporated companies no longer seek a listing in the U.S. after the China Life class action. So what when a China incorporated company seek a listing outside mainland China, the only destination is Hong Kong, and that's what we call a H-share listing. H-share listing still requires CSRC approval, and the regulator is the International Department of the CSRC. Here, I wanted to briefly touch upon this point of H-share full circulation, which is 全流通, H-share 全流通. It is important for existing shareholders in the company because the primary goal when a company seek a listing, one goal for the company is to seek fundraising. Another goal is to seek liquidity, and liquidity is more important to the investors, to the existing investors, right? Because most of the investors, in particular the PE investors, when they invest in a company, they have this goal of eventual liquidity and exit, so that they can sell their investments in the public market and reap their rewards. So circulation and liquidity is very important for existing shareholders. But for many years, the H-share route does not provide full circulation. What it means is that when a company is listed in the H-share market, the company can raise funds from the Hong Kong capital market. But most of the shareholders would not be able to have liquidity. Their shares, in particular, the investors who are Chinese persons, Chinese companies, they would still be holding domestic shares that are not tradable in the Hong Kong market. So listing does no good to these, no direct good to these existing shareholders. And the regulators have noticed this issue for a long time, and they understood that the market calls for further opening up, so that the existing shareholders can benefit from a company's listing as well. So starting this year, the CSRC has fully implemented the program of H-share full circulation. That means nowadays, when a company seeks an H-share listing, it can apply for full circulation of the shares that are held by Chinese investors. Once applied and approved, those Chinese investors' shareholding would also be tradable in the H-share market. And lastly, just wanted to very briefly talk about a very hot concept here, which is the SPAC listing. What are SPACs? SPACs are listed shell companies. How it operates is like this. Certain investors gather together and create a shell company that has nothing but cash. They list this company, and in the prospectus, they state very clearly that this is a shell company, and this shell company will do an acquisition within 2 years' time with the funds raised. And in 2 years' time, when the shell company acquires a target, that process is called a de-SPAC. And upon de-SPAC, the target company becomes listed because the target company's assets will be injected into the listing shell, and the shareholders of the target, the existing shareholders of the target will become shareholders in a listed company. And all the companies, all the public shareholders who invested during the SPAC stage will then naturally become shareholders shareholders of the target assets. So the SPAC concept has been very popular in the past one or 2 years in the US, and Hong Kong has now also formulated its SPAC listing rules, but it's still subject to consultation. But we don't have this option in Asia market yet, and I doubt we will have that because SPAC conflicts with so many Asia regulatory principles. So I doubt that the regulators here in China would go that far in a very short period of time. So this becomes another option that investors can have in the Hong Kong market, but that is not available in the Asia market. So that's all for my materials. I'm not sure whether you have any questions. Thanks very much.
Thank you very much, Lanjie, for the truly wonderful presentation. You have provided a fantastic presentation about the regulatory framework, especially the recent regulatory development, and also the kind of details which we as scholars do not pay attention to. And our students, we discussed some of the issues in our class, but the insights you provided from a practitioner's perspective, and not just any practitioner, it is a practitioner who has participated in many of those high-end top transactions. So this is very good. So I would now like to we start without further ado. We start the discussion part. I would like to first invite Dr. Charles Chu, who already retired, but I think his spirit is still with us very much, and he's the author of a leading textbook on Hong Kong company law, and one of the very few scholars I know who understand Hong Kong company law so well. So Charles, would you please start first?
Yeah, thank you very much, John, for inviting me, and thank I also am grateful to Ms. Lan, who give us such a wonderful talk. And but before I start my discussion, may I please ask Ms. Lan a question? We were talking about the red chip structure and all of that. Is it right to say that the holding company within this structure is always the overseas incorporated company?
Yes.
Right.
Yes.
Okay.
Yes.
So does that mean that the so-called keep well agreement has nothing to do? It's not relevant to red chip companies? And there's a recent Washington case in Shanghai, right? And then I think there was a keep well agreement issue there, because in that case, the holding company was actually located in the mainland, but the subsidiary is, I think, was incorporated in Cayman Island. And then the Cayman Island company was trying to raise funds, right, through issuing so-called bonds, unsecured. It was unsecured credit, but then the investor, the creditors, were given a keep well agreement by the holding company in China, right? And then and then in the contract there was this term that the jurisdiction-wise, Hong Kong court has a jurisdiction if any issues arising out of this keep well contract, keep well agreement. The applicable law was English law. And then the creditor was suing. The holding company did not keep the promise. Keep well contract says that, I'm not going to give you a guarantee, my subsidiary is borrowing money, but all I can do is to give you some sort of gentleman agreement. I make sure that they are always properly financed. I mean, my subsidiary, right? And if there's anything wrong, you can sue me. Right? And then there was a bit of a private international law issue because the parent company in China was saying that, look, Hong Kong court doesn't have jurisdiction and all of that, so we have some interesting private international law issues, right? But if this is irrelevant at all to what you have talked about, then I was thinking whether this would be relevant because I was trying to put things in perspective.
Yeah, understood.
Yeah.
Yeah, understood. Professor Chu. I think my understanding is that the keep well agreement concept is still applicable here in a red chip structure. If the red chip companies decides to do a fundraising, to do a bond issuance, right? So so the parent company, but in this structure, it's kind of hard to imagine how the overseas bond offering will be issued because for a keep well letter to be issued, it's most likely that it will be the WFOE that will be issuing the bonds, and then the Cayman parent will be issuing the keep well comfort to the bond holders. But I think in China the issuance of bonds by the WFOEs will be subject to CSR's, subject to safe requirement and also NDRC registration. So it's kind of hard to imagine that the WFOE would be able to do such a bond offering. And I think in the case that you described, I can totally imagine why that was the reaction from the Chinese parent. So in that case, the parent is Chinese companies, and it's the opposite of what we listed here, right? Is parent China company is on the top as a parent, and then the bond issuing subsidiary is overseas, and the China parent issued the keep well comfort to the bond holders. However, I think the China parent was trying to avoid 内保外债登记 because when a China parent is guaranteeing an overseas debt of its subsidiary, it triggers the 内保外贷 regulation in China, which could be problematic. And so that's why I think they did not do a real guarantee in the first place. They chose a keep well, which is non-binding by nature. And I think the best that they can say is that we will keep our subsidiaries well funded, and you can sue us, right? But you cannot sue me as a guarantor because I'm not a guarantor of the bond.
Right. Yeah. Yeah. Very good. Thank you so much. And actually, my understanding is that the reason they gave this keep well agreement was that precisely that if it was a guarantee, then it has to be registered with SAFE, right? But if it was not, then there's no such a requirement. But thanks so much for the explanation. And this talk is indeed really informative for me personally, because, for example, I didn't know before your talk that the Chinese regulator has already given sort of a blessing to the VIE structure. I didn't know. I was not aware of that. And I was not aware of the existence of CDR, although I was aware of ADR. And also, I was not aware of stock, which is quite interesting. And I was wondering what's the rationale? Was it efficiency? You know, why do we want to have it, right? It can't be for fostering technology companies. As you know, is it for the purpose of efficiency?
You mean the starboard?
Yeah, the stock listing. The last thing you talk about.
Spec. In China, we don't have that yet. In the mainland market, we don't have that yet. Yeah. I think, you know, in the US and Hong Kong, it is very attractive because of two things. One is indeed, as you said, efficiency. Because when the SPAC does a listing, the SPAC does not have any assets, and therefore there is no due diligence. And the prospectus would be very simple. It all looks the same, right? It all looks pretty much the same, other than the parts where they describe they have sponsors. Then they just focus on the CVs of those individuals, you know, and a very general description of the strategy going forward, etc. So the listing process is very, very fast. And then at the time of de-SPAC, it's sort of like a backdoor listing. Right, it's sort of like a backdoor listing, but with I think, you know, with probably more, it operates like a backdoor listing, but at that point in time, you already have the public shareholders there, right? So so it's a reverse takeover.
Right. Now, also I was I understand that most of the attendees here are students, so I was wanting to say a few words from the students' perspective, and I just want to say a few words how I think Ms. Lan's talk help us to put Hong Kong corporate law and corporate insolvency law in perspective. And the first point I want to quickly mention is that in fact, I'm talking about the red chip listing thing, right? Foreign incorporated entities are, for me, you know, they are just corporate proxies for Chinese undertaking. And it's quite interesting that, you know, Chinese entities are subject to common law because of this red chip arrangement, right? Subject to the regulation of common law, okay? So, and you see, of course, the keep well thing we were talking about was also caused by various types of cross-border arrangements. And also it reminds me of the notion and the significance of what we call non-Hong Kong companies in Hong Kong. Because, you know, remember, non-Hong Kong companies are foreign companies who has got a place of business in Hong Kong. And the reason why I want to mention this is that close to, according to my information, which I acquired 2 years ago, according to close to 90% of the companies listed in Hong Kong are actually not incorporated in Hong Kong. They are incorporated overseas, right? A lot of them are incorporated in tax havens like Cayman Island and Bermuda, right? And BVI for various reasons. So that, you know, tells us the importance of that part of the law in the corporate in Cap 622. And a lot of, as I said, a lot of these companies are actually Chinese companies, right? But they are also Hong Kong companies, like the Cam Long Sui Kwan case, you know, the restaurant which became bankrupt a few years ago and so famous. It was also incorporated in a tax haven for the purpose of tax planning and all of that. Yeah, and I want to be very quite brief, and apart from the keep well thing, I want to talk about 2 more points. One of them is to do with corporate insolvency, and the other is to do with corporate governance. And the second point was related to what one point pointed out by Ms. Lan, you know, the difficulty of cross-border enforcement. Okay, now On the cross-border insolvency part, what I want to mention is that until recently, Harris J of the first instance court in Hong Kong has was facing a lot of cases from offshore territories, mainly from Bermuda and the Cayman Islands, mostly from Bermuda actually. And the reason is this, because of the red chip structure really. The company was incorporated, right? But they are, for tax purposes, they are listed in Hong Kong. If the company is listed in Hong Kong, when the shareholders transfer their shares, the withholding tax will be lower than if it is listed elsewhere, right? And then so, but when the company goes under, we have COVID and all of that, and then there's a need for probably corporate rescue, restructuring, and all of that. And for doing the restructuring, you need to, for example, moratorium, a stay of proceedings, right? But in Hong Kong, it's very difficult because we don't have purpose-built corporate rescue procedure, okay? We have a scheme of arrangement regime which does not contain stay of proceeding procedure. And it used to be that we could use provisional liquidation provisions to obtain a stay, because once a provisional liquidator is appointed, a stay is automatically triggered. But because of, I think, 2005 decision of the High Court, and this, people became suspicious whether that can be done in Hong Kong, because that court said that provisional liquidators are appointed to wind up a company, for winding up a company, not for saving a company. So they were not sure, right? But then in the offshore islands, in both Bermuda and Cayman Islands, they have this so-called soft touch provisional liquidation, okay, which can be used to trigger moratorium, and they do, okay, and their provisional liquidation is different from ours. So a practice has been developed a few years ago, to whereby the Hong Kong companies, the Hong Kong part or Hong Kong member of this corporate group, if the holding company or whatever, if the company is incorporated in Cayman or Bermuda, could petition for its own winding up in where soft provisional liquidation is available. And then the court from Cayman Island or from Bermuda, they can request a recognition of their liquidator and their procedure, okay, to the Hong Kong court. And they can ask the Hong Kong court for judicial assistance. And the form of judicial assistance requested was moratorium, okay? So for a number of years, that was actually possible, okay? And indeed, Harris J even designed a set of standard, clause on the standard order, granting the moratorium, among other things, to the foreign companies, to the representative of foreign companies. But it's stopped recently for some reason. Okay, so you see, this kind, and so Harris J was facing the issue, whether this is right to do so. It's like we're giving automatic stay, right? To, we're taking advantage of what is available overseas, right? We don't have that in Hong Kong, but we'll take advantage of what is available in offshore island, offshore territories. Okay, so there's we won't have this issue if we didn't have the red chip structure thing. Okay. Now the second thing I want to mention very quickly is to do with corporate governance. And I recently have seen a case where, and this company was incorporated in Cayman Island, and then this company was able to borrow a lot of money, unsecured so-called bonds, they're not bonds, from Chinese citizens with a remarkably low rate of interest when the company was badly distressed. Okay, when, if the company is badly distressed, the company directors should not be permitted to borrow money anymore, right? Because now the company's interest is the interest of the aggregate interest of the creditors, right? Now, I was shocked because I haven't seen this kind of cases before, okay? Now, I checked out Cayman Island company law. They do have a common law, case law on the director's duties to have regard to creditors' interest when the company is on the verge of insolvency and all of that. So what this tells me is that what the law they have does not really matter, It's because it's so far, and it's probably difficult to effect cross-border enforcement. That fact probably emboldened the directors to do wrong things, And those Chinese citizens were willing to do this because we have a rule in Hong Kong. If you invest a large sum of money into a listed company in Hong Kong, you get your Hong Kong citizen permanent residence, right? And also you can also bypass Chinese mainland regulation on foreign currency control and things like that. Okay, but then Harris J was facing this issue, but I think, of course, he decided the case correctly. But what this tells me is that this is also a red chip company, by the way. Okay, now so this kind of arrangement can give rise to various types of corporate insolvency issues, corporate governance issues, and even the keep well agreement issue, which is quite interesting, And yeah, so this is basically what I want to talk about. I know, I'm sorry, I've taken a lot of time, and I just want to put things into perspective. I think your talk has contributed to our
Thank you very much, Charles. The first part of your talk can be moved to the question and answer part. So
all right, okay.
Your own comment part within the time period allocated to you. I would now like to invite Professor Wang Wai-Yi to have some comments. Professor Wang teaches company law here, and she's also a leading authority on company law and insolvency law. And recently she has dived into Chinese law, so should be a very suitable commentator here. Please.
Right. Thank you, Professor Wang. First of all, thank you again for inviting me to be a commentator for this wonderful talk by Lan. It has been 2 decades since I was in private practice, where I did some of the IPOs involving Chinese concept stocks, but that was in Singapore. And a lot of the issues that were raised then, of course, cannot compare in relation to the complexity that we see the issues raised here. So what I will do is that when I'm giving commentary on the presentation, some parts of it will be the questions, but I think perhaps the questions can be dealt with after the commentary has been given by myself and Professor Lin. So this talk is extremely informative and really gives a very good background as to the ways in which we look at the listing mechanisms of the Chinese concept stock. I have a number of comments. The first of which is that looking at, for example, the slide which is on the screen here, it says what is a typical chip structure. I must admit that when I first looked into research on Chinese concept stocks in relation to corporate governance about 5 years ago, when I was still in Singapore Academic Institution, one thing that really puzzled me and I tried to find out was how do we define a red chip company? How do we know whether something is a Chinese concept stock? This has been something which has really piqued my interest because we were at the time looking at whether there were any differences in the Chinese concept stocks that were listed in Singapore versus those that were listed in Hong Kong. But we found out that there was really no definition that is necessarily adopted as to what amounts to a Chinese concept stock. The second question that I have is that I found the lockup requirements for controlling shareholders post-listing to be quite interesting. I didn't realize that in mainland China, the controlling shareholders have to lock up their shares for as long as 3 years. My question then is that whether the lockup is in fact a hard lockup, or whether there are ways in which the parties can, for example, lend out their shares or do anything else which do not amount to an outright disposal, but still enable them to be able to utilize the economic functions of holding these shares. So moving on to the comments as to on the conflicts that exist between the PCAOB as well as the Chinese requirements on the sharing of the, especially on the audit requirements. Now, this is, and I find that the current practice where now, where I think Ms. Tan mentioned that there is, in terms of due diligence, while we are used to the financial due diligence, we are used to the legal and regulatory due diligence, and now there's a full set of the China-related questions, and some I think it might be interesting to find out what are some of the major issues which have caused problems for companies to disclose under the China-related questions. Now I move on to the cross-border enforcement. Now, cross-border enforcement is always an issue, and has always been an issue, especially for the companies who are using Hong Kong as a basis for fundraising, but their operations are elsewhere. So when I did research previously on these issues, it was a slightly different context. It was the cross-border enforcement in relation to the Chinese concept stocks, which are listed in Singapore, but the main operations are in mainland China. And in terms of how we have found is that lots of the cross-border enforcement will not be done via private shareholder litigation, at least those which are in the case of Singapore and in the case of Hong Kong as well. A lot of it will actually be done via public enforcement through the regulatory authorities. So that then raises the next question is that when we talk about the disclosures that are typically made in the IPO prospectus, or well, when we say that there is difficulty in cross-border enforcement, there's no question about that. But actually, given that we're looking at, say, Hong Kong, and a lot of the enforcement is done via public enforcement, a lot of it is done via, and in terms of securities, at least not class actions, but securities actions, they're done by the securities regulator. Then, of course, it's not comprehensive. It will not cover every single situation. But we have also seen securities regulator, SFC, in Hong Kong being very active and finding ways to be able to reach out, even for the companies which are whose directors are not in Hong Kong at the time. So that's something which I wonder whether, in terms of the disclosures, that there needs to be any kind of a tweaking. I'm also intrigued by the fact that there are companies which choose to be dual listed as opposed to getting a secondary listing in Hong Kong. So I'm also curious to know why companies would choose to have a dual listing, being listed on the in both China and Hong Kong, because given I would have thought the more onerous obligations that you need to comply with when it comes to any conflict. Okay, so one comment which I was looking at right at the initial charts in relation to the return of the unicorns, and because I'm now also looking into Chinese bankruptcy law, my reaction was that given that there's going to be a number of unicorns or companies which are incorporated outside of China and going and listing on the Asia share markets. Well, these are unicorns, but at some point in time in the future, there may be insolvency proceedings that need to be brought into play. And as far as I understand it, the enterprise bankruptcy law is not really set up to deal with companies which are incorporated overseas, but with operations in China. So I'll be interested actually to see whether in the upcoming changes, whether in the bankruptcy regime, whether that's something which may need to be relooked at. Okay. Again, on the ways the unicorns have listed, I was actually quite surprised to find out that CDRs, the China Depository Receipts, are not a common method, and rather the choice by the issuers is to they select to use the A-share market. I think in terms of, well, just looking on the simplistic corporate governance perspective, I thought that's not a bad thing, because with the CDRs, it's usually more difficult to exercise your voting rights compared if you hold directly at the A-share market. Now, the final comment I will make is in respect of SPAC listing in Hong Kong. Again, when I put on my bankruptcy law hat, my reaction was that with the rise of SPAC listing, I suspect that there would be very, very few reverse takeovers or backdoor listings that are going to happen, because if an investor has has assets which they intend to be listed, they would rather go for SPAC than to actually find a company to do a reverse takeover, because although you already have an existing base of shareholders, it actually is a lot more work, because you have to actually negotiate with the controlling shareholders and to decide how on the valuation. So I think that's all that I have for the comments. And again, many thanks to Ms. Lan for the excellent presentation. And I look forward to hearing your responses.
Thank you very much, Wai. I hope Lanjie has been keeping notes, because I would like to invite her to respond after the comment of our the third discussion. Dr. Lin Yixin. Dr. Lin teaches capital markets law, which is securities regulation in Hong Kong, and she has done first-class research on corporate governance, and especially state-owned enterprise governance in Chinese companies. Yixin, please.
Thank you, Professor Wang. And thank you, Ms. Lan, for the wonderful talk. I think Ms. Lan has done a wonderful job of updating us, on the recent developments of Chinese companies listed, especially overseas. Actually, I'm same as Wai. Before I joined the academia, I was also an IPO lawyer, so I'm quite interested in this topic. And I have paid attention to the Chinese companies listed overseas in the past years. So I think this topic is very important, especially for Hong Kong, because Chinese companies actually, are important for Hong Kong Stock Exchange. So I have the latest statistics, which is as of July this year. Actually, Chinese companies, the number of Chinese companies listed on Hong Kong Stock Exchange, they comprise of 54%. Of the listed companies in Hong Kong. And also in terms of market value, it's even higher. It's almost account for 80% of the market value of Hong Kong Stock Exchange. So I think Hong Kong has done a good job since the regulatory changes, in 2018 to allow, dual class share, WVR firms, and also the new economy firm and the biotech firm to list in Hong Kong. So they attract a lot of Chinese companies in that respect. So Ms. Lan has gave us a quite complete update, including the recent regulatory conflict between US and China about auditing, and also the development on the SPAC, listing, the possibility of SPAC listing, and also the the regulatory challenges posed by Chinese governments in recent listing in the US. So what I want to do is really to to take a different perspective and to share with you my personal observations of the historical trend of Chinese companies listed overseas. So if it's okay, I'd like to share maybe some graphs with you,
Sure.
if that's possible.
Yeah. So
yeah.
I mean, and you can, yes, you can share the screen.
Okay, great, thank you.
That's very good. So that's almost another seminar.
No, it's just a few graphs. I thought it would be nice to share because I want to look at the historical trend. So for this graph, can you see the share screen? Yes. Okay, so as you can see here, this is the statistic from 2014 to 2020. I couldn't find a more complete data that back to maybe 2007. But from here, you can see that the US listing is the great one, right? That in 2014, actually, there are still quite a number of US listings by Chinese companies. But over time, like in 2015 and until 2020, actually, there are very few US listings. And most of them come to, the listing goes to like Hong Kong, right? If you see the dark blue one, 2015, we see a lot of listing in Hong Kong. 2018, we see a lot of listing in Hong Kong. And also for the member, the A-share listing, we see a constant, quite a constant number of listing here. So actually, if you, I have the data, I would love to show that actually there's the first peak of US listing actually go back to like around 2007 to 2010, where there were around like at least 150 Chinese firms listed in the US. And back then, they list their shares by way of a backdoor listing. Okay, so it's like a reverse merger. Okay, so that wave of listing, actually, the quality of Chinese firms that list in the US at that time was not that good. Okay, because they do it from backdoor listing, and there's not a rigorous review from the stock exchange if you're done by backdoor listing. So that triggers actually a wave of privatization, okay, delisting from the US, because I think around 2010, there's this called the muddy water, right? There's short sellers, firms, they disclose on the website about the accounting fraud by these Chinese companies. So then triggers a wave of class actions against Chinese firms, especially the reverse merger firms, in around 2010 to 2011. Okay, so that firms, and the firms that listed before 2010 actually are subject to a very high risk, or they has been sued by US class action attorneys. So that triggers a wave of delisting in 2011 and 2012 of Chinese companies. And I would say that most of the firms that delist from the US at that time are, most of them are firms that have poor quality in accounting and also disclosure, okay? And that get sued, and they seek, a lot of them maybe they just delist from the US and didn't really come back to list in Hong Kong or in mainland China, because actually the A-share listing requirement is quite high, okay, higher than those of the US. And we can see another wave of privatization from this graph is in 2015, okay? So in 2015, actually, at that time, I would say that, for example, a firm that delist from the US and then seek a listing in mainland and also in Hong Kong is Qihu 360, which is a very good firm. Okay, they also want to retreat from the US market. Why is that? It's because of the reputation of Chinese firm has been harmed by the lower quality of firms that list in the US before 2010. So there's tend to be a lower valuation of Chinese firms in the US market. And the other reason is that a lot of the business model of Chinese companies, they are not that well known or understood by the US investors because of the unique business model that are in China. Okay, it's different from that in the US. For example, how the the online shopping, like Taobao, and all those business models are very different from Amazon and firms that U.S. investors they are familiar with. So because of this lower valuation and the very high valuation of firms, the high PE ratio in the Chinese market. So the firms, the Chinese firms that list in the U.S., they want to come back to Asia market or to list in Hong Kong during 2015. But so a lot of firms actually privatized. They did a privatization, a buyout by management in 2015. But then we all know that there's a stock crash in the latter half of 2015 in the Chinese market. So a lot of firms actually stock there because they already did the privatization and they want to seek a listing in Asia or in Hong Kong market. But it took them quite some time to come back, not only because of the stock crash in the Asia market, but also partly because they had to deal with the issue of VIE and also the dual class share structure. Okay, so they need to do some restructuring in order to come back. So that's the story of Chinese firms listed in the U.S. And this graph shows you the class action file against Chinese reverse merger company. Remember that I said a lot of firms that listed in the U.S. before 2010, they were sued in the U.S. So especially there is a peak of U.S. class action in 2010 and 2011. Okay, so this is a graph of class actions between 2009 to 2011. So there is a peak of class action against Chinese reverse merger companies, but that goes down after 2012. So, so in summary, there is I think, a historical trend that can be, separated in different stages. One is in 2011 and 2012, where this low quality of, Chinese reverse merger listing, they're subject to U.S. The more rigorous litigation in the U.S. And in 2015, because of the lower valuation in the U.S. market, so some very good firms, they still seek to come back to list their shares in Hong Kong and the U.S. And back to the 2018, as I said, at that time, because of regulatory competition. So we know that in 2014, Alibaba listed their shares in the US. And that was when Hong Kong wanted to seek listing of this new economy firm, the whole generation of the high-tech companies. So we know that Hong Kong started to do the consultation on allowing these dual class share firms to list in Hong Kong from 2014. And after 3 rounds of consultation, it took 4 years for Hong Kong to accept or to open up their market to this new economy firm, to dual class share firms. So I think the peak, if you can see, there's a peak of Hong Kong listing in 2018, right? That and also 2019. That was due to the regulatory change, the regulatory competition. That's what we always said in the literature, right? There's a regulatory competition among international stock exchanges. That's between Hong Kong and the US, and also Singapore as well. So they are compete for this high-tech firms, dual class share firms, to list in their market. So that's the story before 2018. And I would say that before that, actually, most of the considerations for listing are actually business considerations, right? They think about the litigation costs, the firms, they consider, whether the valuation is better, which market has a better valuation, and also, the regulatory arbitrage, that if they can benefit from the structure, or there's a loosened, regulatory structure in which market, like in Hong Kong, they open up the market in 2018, and they're willing to come back, okay? But after 2019, I would say there's a different story. So from 2019 to now, I think the listing market are mostly affected by the geopolitics or geopolitical factors, stemming from the US-China trade war in 2019, later on the cybersecurity review by Chinese market, and also the Holding Foreign Company Accountable Act by the US government. So that's my personal observation. Of course, I would love to hear Ms. Lan's observation based on her experience in the past years assisting Chinese firms to list in the US or in Hong Kong. And I think in the process, we can imagine, for the future, we can see that there are more Chinese firms who will come back because of the geopolitical change in recent years. And Hong Kong, of course, is the one of the biggest beneficiaries in this change. So I would love to hear Ms. Lan's view on, maybe the challenges ahead for, the firms that want to raise funds in the overseas market, and what does she see that are the factors that would affect a firm's decision in choosing the listing destination. Okay, that's all my sharing. Thank you.
Thank you very much, Yuxin, for the both for the information and for the insightful analysis. Before we open up the floor for questions from the audience, I would like to invite Lanjie to respond, either responding to the questions and the comments from the discussants, and also your further analysis if you have any, please. You have to unmute yourself.
Sure. Let me go back to my slides. I think I've written down most of the questions, but I may have missed. So I think Professor Chu's two questions probably don't belong, right? Because those were, Mr. Chu made two very valuable observations on the cross-border bankruptcy practices, as well as corporate governance issues. So I think those are, if I understood it correctly, I probably don't need to respond to those. Ms. Wang raised a number of questions. The first one is whether there is a definition of China concept stocks. Is that correct?
Yes, that's right.
Yes, yeah. I think that's a very good question. I think in my idea, if we have a very typical red chip company would have all these three elements. So Chinese at the two ends, at the top and then at the bottom, and then overseas structure in between. So this is a typical red chip structure. But I think in a China-based China concept stock, it probably has a wider scope. And I think if it only has this bits, it will be captured as a China concept stocks. And I think this is the way that both the US and the Hong Kong regulators would look at an IPO applicant when it reviews the prospectuses. So whenever there is substantial operations going on in China, I think the reviewers will naturally think of what are the complications and what kind of rules and regulations that these operational companies need to comply with. What if there is a policy change and therefore affecting the operations? What are the risks to the investors in my jurisdiction, which is who I need to protect? So I think they will probably pay most attention to these. It's just that naturally PRC operations are quite often owned by PRC persons, even though indirectly. So a lot of times when we have this layer of China elements, we also have China elements here at this layer. But then in some circumstances, the holders are PRC I mean, they have a PRC background, but sometimes they have already immigrated to other countries, right? In which case, it's no longer, from a pure PRC regulatory perspective, it no longer faces, the 10号令, the Circular 10 issues, or the safe registration issue, which is a blessing to the Chinese lawyers, because we don't need to worry about those two issues. And then most of the times we probably won't refer to them as red chip companies, but I think they are still China concept companies. So I'm not sure whether that answered your question.
Yes, it does. Thank you.
Thank you. So actually, I think I forgot maybe a couple of questions, but the next on my list is the enforcement risk. So would you remind me what else have I forgot before the enforcement risk disclosure point?
Oh, I was asking in relation to the lockup arrangements, whether it's a hard lockup.
Yes, lockup. Indeed, it is very harsh in Asia market for controlling shareholders. And the short answer is that yes, it's hard lockup. And there is a background to this hard to this requirement. The most important is that listing in China has always been sort of a listing status is almost like something like a luxury. Listing resources is very scarce, and it's something worth fighting for. And therefore, the CSRC, who is protecting the public investors, their concern is always that look, you cannot come and crop the, in China we say 割韭菜. You cannot crop these leaks and then immediately go away. So controlling shareholders, I want you to have long-term commitments. Actually, this is a control stability. If you look at one of the charts, control stability of control. But we have very long stability of control requirements in Asia market. This is before listing. Before listing, the applicant needs to demonstrate that it has satisfied at least 3 years or 2 years of control stability. And post listing, the requirement is still there. I mean, it is enforced by the lockup. The CSRC does not want the controlling shareholder to abandon this company immediately while he had, while the public investors invested. So they want the controlling shareholder to stay there for as long as possible. So that yeah, that's that. And what is the next question?
I think it will be enforcement. Yes.
Oh yes, enforcement. Yes. Well, if you, I think the enforcement risk. It's very nice to hear the recent updates, and to hear that actually nowadays it's probably getting easier for investors to have their claims enforced. In terms of disclosure, I think well, I think lawyers how can I say, the prospectus get lawyers look at precedents. Prospectus get referred to or copied, from case to case and to case. And I think if you open the prospectus, there are probably 10 or 20 or 30 pages of risk factors. A lot of that will deal with the business, the particular industries that the company operates in, the particular structures, and also some of the specific circumstances. For example, whether the company is labor in labor-intensive industry, in which case the labor law compliance issues would require some disclosure, and also the competitive landscape in the industry, etc. And then there will be a country level risk factor that would include a lot of the PRC risk factors, for example, safe, M&A restrictions, etc., etc. And then the last group of risk factors is the risk factors relating to the offering itself, and those are very standard because every offering faces the same risks. There is a risk of dilution to the existing shareholders. Actually, there is a risk of dilution to the to the new investors in the IPO, because they will be investing at a higher price than the existing shareholders. There will be risk factors relating to their exercise of the shareholders' rights, etc. And there will be this risk about, enforcement. If in the future some of the public investors are not happy with the company, with the disclosure, for example, and they initiated a lawsuit, and they win the lawsuit, there is no guarantee that their loss will be duly compensated, even if they win the lawsuit, because we have this enforcement difficulty there. So it's good news that the difficulty may have been mitigated to a certain extent by the various actions that the public sector is taking, but the risk is still there. And I think from an IPO perspective, the most important thing is to disclose the risk to the investors, so that when the risk really materializes in the future, the issuer and the investment bankers, lawyers can say that, look, I told you that, I warned you already. So this is not a basis for you to sue me. Therefore, in that context, it's not a problem if the risk is disclosed as too harsh. It is a problem if the risk is not sufficiently disclosed. Therefore, I think it would be nice to add something to reflect the development that you described, but it's not. It would not be the first priority in most of the prospectuses. In most of the lawyers who are drafting the prospectus, they would think there are other, to disclose more risks is actually a protection for everybody. Yeah. And I think the next on my list was dual listing. Yes, indeed. I think you raised a very good point, and actually I don't think I have the answer to that either. What I know was that secondary listing, as you said, rightly pointed out, actually is subject to certain exemptions. I mean, it would be easier for a company to seek a secondary listing in Hong Kong instead of a dual primary listing in Hong Kong if it's already listed somewhere else. So it's interesting. I also wonder, why those few companies choose to do a dual primary listing, and I think it's probably because they do not satisfy the requirements for dual primary listing. Because if you look at the examples here, these guys are very strong, right? Alibaba and Jingdong. They are very well-known names. So I think, it's probably because they have satisfied the requirements applicable to secondary listing, while these tend to look much smaller, right? So that's just my guess, but I don't know the exact answer to that one. And the next on my list is bankruptcy law for companies incorporated outside China. How does it? Yes, you are very right that bankruptcy law in China only applies to companies that are incorporated in China under the PRC company law. So if it's let's go back to our structure chart. So in this case, if it's this company that is going bankruptcy, China law will not apply. It will be conducted. The bankruptcy process will be conducted in accordance with Hong Kong law. But that doesn't mean that China laws is entirely irrelevant, because in this structure, this would be a holding company. It doesn't have any real assets, right? The real assets are here. So, and the bankruptcy and distribution of these would be subject to the PRC laws. So let's say this company is bankrupted. It needs to be liquidated and then distribute whatever remaining assets it has to its shareholder. Then in order for it to that, it needs to get the assets distributed from the WFI, and then it can do the upstream distribution further. So that's where the PRC bankruptcy law would come into play. So that's my understanding of the circumstance. But I'm not a bankruptcy lawyer. It's just my understanding as a corporate lawyer. Yeah. And then the next question that I have written down is CDR versus A-share, and I think that's a very good question too. I think the CDR program was designed for to welcome companies incorporated outside China to come and list in China. The CDR program, it designed actually for two purposes. One is to welcome the unicorns to come back. Those are China-based companies. The typical examples would be Alibaba, etc. And another purpose was actually to attract some of the truly international companies to come and list in China. And you have probably read from the news that a couple of years ago the CSRC started the Stock Connect program, the London Shanghai Stock Connect program, where they wanted to welcome some of the London listed companies to come and list in China. And at the same time, a couple of Chinese companies have already gone out and issued GDRs, which are global depository receipts. They've issued GDRs in the London market. But unfortunately, up till now, the Eastern bound GDR program is not yet open. I mean, no London-based issuers have come and listed in China yet for a lot of reasons. I personally actually assisted a leading international issuer in its attempt to seek a listing on the China seek a listing of CDR in Shanghai, and we participated in a lot of discussions with the regulators, etc. But unfortunately, there is still a significant difference in views between the overseas issuer and the regulator. So that doesn't happen yet. But in any case, so CDR was designed to enable these two types of companies to come and list in China. So I had also thought that when the red chip company comes back and to China, CDR would be the most natural type of security that it would choose to issue. But interestingly, it is not so yet, and I think it's probably because of the concept of CDR is new, and to sell a security in the market, you need the purchasers, you need the mass investors to be familiar with that concept and be comfortable with it, and therefore then you can create a liquid market for your securities, right? And I think that is probably one reason why CDR has not yet been rolled out on a very big scale yet. Actually, I worked on an IPO by international company who was thinking of that international company was already acquired by a Chinese state-owned enterprise, and the China parent wants to bring it back and list it in Asia market. So the natural instrument for that company to issue is CDR, right? And we presented the CDR proposal. I mean, the lawyers and the investment banks presented the CDR proposal to the company. But after a couple of weeks, the company said, the senior officer of the company said, wait a minute, what is a CDR? Nobody knows that. If I sell CDR, can you guarantee that I will be able to sell the company at the desired, valuation? And can you guarantee that there will be a liquid market afterwards? So at that point in time, he changed the whole structure. The company decided to change the whole structure, and now the company is seeking a listing of A shares in China. But however, the listing of A share by red chip companies is not a very natural way to do. I mean, the issues that I explained, the foreign exchange issue, it's a real issue, and it's still not yet resolved. I mean, they are just saving some of the problems for the future, hoping that the regulators will come up with smart resolution for all the problems. So I think and also the current I think there are at the moment, probably 2 or 3 companies have listed Asia. Red chip companies have issued Asia in China, and I think those are all companies with very special background. For example, the 芯片公司 I forgot the name. So those have very special background, and I think their issuance of A shares must have been blessed by the regulators. I mean, even if a written approval was not issued, they must have consulted with the regulators and have got some sort of a blessing or endorsement. So I'm not sure whether the Asia model can be replicated by all the red chip companies yet. So it's still something worth waiting and see. Yes, and the last question that I have is the SPAC versus a real reverse takeover. Indeed, I fully agree with your observation, and I think with the SPAC rolling out, the market for shares would dramatically diminish. No, if not diminish, it will dramatically decline. I mean, currently, I think in Asia and in Hong Kong as well, there is a market for shares because the listing status itself is an asset that is that has some value, especially in China, in Asia market. A listing vehicle itself, a listing status itself could be worth quite some money. But with the SPAC, I think the value of a listing share would diminish significantly because the share, a company that is already listed, not a SPAC, a company that is already listed but is no longer very active. I mean, that is not a very well-performing company, right? I mean, if the company is performing very well, then its share, the price of its shares would have gone up, and the trading would be very active. So that company is, by definition, not a very well-performing company, and therefore that company, by definition, has a lot of historical legacies, troubles, burdens, right? And therefore, when a company that wants to seek a listing through backdoor listing or through, reverse takeover, those historical issues are things that they need to be aware of, because they will be stepping into the shoes of the existing share, and they will be inheriting all the historical problems. Whereas in a SPAC situation, the SPAC is cash company, is entirely clean. So in that regard, I fully agree with you that with the SPAC rolling out, I think the market for reverse takeover will decline. So that's all the questions that I have written down from Ms. Wang. I'm not sure whether I've answered your questions.
Yes, you have. Thanks very much. Thank you.
Yeah. So now moving on to Ms. Lin. Yes, I think Ms. Lin, thanks very much for the very insightful, presentation of the statistics. I think those are amazing indeed, and I actually haven't looked at the trend from the perspective that you presented, and I think it's very, very interesting, and I would agree with your observation as well. In 2014, Alibaba listed in the US. They tried very, very hard to list in Hong Kong. Actually, I worked with Freshfields, Brockhaus Deringer for quite a number of years, and my boss at Freshfields joined Alibaba as the general counsel. So so we know how Hong Kong was actually the first preference, but then Hong Kong system was not flexible enough, and therefore they had to go to the US, and then right after that, Hong Kong started a review of its regulatory regime, and here it is. We now have Hong Kong now allows dual class voting shares. they also allow, they also have special exemptions for biochemical companies, etc. Yeah, and reverse takeover companies that are listed in the US by reverse takeover, indeed, those tend to be lower quality companies because at the time of their listing, they don't have, I have to say, the first-year investment banks, first-year lawyers to review everything, to issue opinion, etc. And they tend to be much riskier. And then there is the muddy water incidents and the various class actions, etc., which all damaged the reputation of China concept stocks in the US as a whole. And recently, I think in the last year, what we've seen is primarily initiated by the PRC governments. I mean, the governments have rolled out some very dramatic policy changes affecting the internet sector and the education sector that causes the investors to have further investors to be more worried about investing in China, and that has also alerted the US regulator. Yes, they have a full set of questions relating to China that they want the applicant to answer during the review process. The typical questions include, for example, let's go back to this chart. For example, the license, permits and license that these companies need to obtain in China, and whether there is any obstacle in fund flow which among the group, in particular cross-border, given the foreign exchange controls in place. Because when the company, this would be the LISCO, right? The US investors would be investing into this company, and then the funds will stay here, right? However, this company and these does not have any operation and therefore has no use of the funds, right? So they have to move the money all the way down here. Then the money can be put to good use to expand their business operations, right? So the SEC asks, is there any obstacle in moving the fund from here to here, and vice versa? I mean, the investors invest here, right? For the investors to reap the benefits of their investments, they need to get dividends from this company, right? They need to get this company will need to pay the dividends, and this company again does not have any operation, so it relies on the dividend distribution from all the way down here, level by level up here, right? So the SEC asks, is there any obstacle in distribution by this company overseas to its shareholders? And this SEC has dealt with a lot of Chinese companies in the past decades, so they are already familiar with a lot of the PRC regulatory issues, including the safe registration issue, right? A lot of this has to do, a lot of the fund flow obstacles has to do with this company's foreign exchange registration, whether this company has a has properly registered with the local SAFE, and and for this company to be properly registered, it actually relies on some of its shareholders to also properly register their investments, and this is the very famous circular 37 registration, 37文登记. So for a Chinese company for a Chinese person, individual, to own shares in the overseas company that owns shares in the domestic company, that Chinese person needs to conduct a circular 37 registration. And it's not always easy to get that registration done. And if that registration is not done, I mean, the PRC regulators cannot go, there is not much that the PRC regulators can do with respect to the individual, right? Even if the regulators go after the individuals, there is probably no real teeth to make the individuals comply, especially if the individuals is actually living outside China. However, what the regulator can do is that, look, if you haven't properly registered, then I can stop. What I can do is that I can stop the fund flow here. Right? I can prevent the WFOE from distribute dividends. I can also prevent the Hong Kong company from injecting further capital into the WFOE. And if that is done, then money is like blood for this company, right? The circulation of blood would be blocked, right? So that is why safe registration and foreign exchange control issue is very important for red chip companies. But but of course, this all depends on how actively SAFE will enforce the rules, right? I mean, we see a lot of prospectus disclosure where the listing applicant discloses that, well, we cannot assure you, we are not always informed of the identity of our ultimate shareholders, and we cannot assure you that all our PRC individual shareholders have registered as they are supposed to do. And therefore, we cannot assure you that there won't be any problem. So at least from a securities liability perspective, this risk is already fully disclosed to the investors. Yeah. So I'm not sure whether Ms. Lin, I've answered all your questions.
Yeah, thank you. I think I will leave time to the to the floor and the participants. Thank you very much.
Yeah, no problem.
Thank you very much for the question and the answers. Which have made our discussion very, very dynamic. I think it's now probably time to open up the floor from the public participants to see if they have any questions. We need to address a few questions which are already in the chat box. I think we have two. Li Xin's question, very much a comment. I think it was tied to Charles' question regarding Keepwell, right? And we can probably start with the second one from Kitty Zhengxin. So the first question very much about the cybersecurity assessment on Chinese companies to list in Hong Kong. I think you very much touched upon that question a bit, but would you be willing to give a more systematic answer now, Lan Jie?
Yeah, sure. I think let me start with this question, which is the draft measure concerning security, cybersecurity assessment. What this draft measure said was that if the issuer, if the listing applicant deal has more than 1 million users data, then before it seeks a listing, 国外 overseas listing, it needs to pass the cybersecurity review. So the term used here is 国外上市 instead of 境外上市. If the typical historically the term used has always been 境外上市, and 境外上市 includes Hong Kong as well. Actually, for a company to seek a listing in H-share, the major rules applicable is 到境外上市公司的监管. But interestingly, the term used here in this draft measure is 国外. And people are saying that, look, the regulators have chosen this word intentionally to avoid capturing Hong Kong, because Hong Kong is not 国外. Hong Kong is part of China. It's not a different country. And also, and therefore, if this is indeed the intention, then that could mean that the cybersecurity review would not be applicable to companies, to red chip companies seeking a listing in Hong Kong. It will only be applicable if the companies are seeking a listing in the US or Singapore, in other foreign countries. But this is just market speculation, so we need to wait and see, and see what the final rules would say in this regard.
Excuse me.
Yeah.
Ms. Lan, the question is asked by me, and actually that the PRC cybersecurity review measures you mentioned is released or issued on 10 July 2021, the revised draft for comment. But my question actually is the one update. It's the measures concerning the security assessment for cross-border data transfer. So it was not listing in the foreign country, it's cross-border data transfer. I mean, the cross-border, obviously, I think it's include Hong Kong, but of course, not every Hong Kong listed company would involve data transfer. So that would be a subtle, differential or distinguish between these two. But okay. I think it still impact that some Chinese companies to consider to list it in Hong Kong. It seems not that intrusive as the cybersecurity review in July this year, but it still set a new obstacles for company to consider. Yeah.
Right. Sorry, I misunderstood your question. Well, if it's the data security, well, I have to say that I need to look at that rule, and in particular, I have to look at that rule and see whether there is any reference to listing. I mean, if it's just on data security, on cross-border data transfer, and does not relate to listing, then I think the impact will be lower. And I think the question. The question would be that, in this type of a structure, when this company is listed, does the listing itself prompt transfer of consumers' data or customers' data from these companies to Lisco? And my imagination would be no, right? I mean, just because this top level company is doing a fundraising, does it mean that it needs to gather all the underlying business operation related data here? It doesn't look very likely, but needless to say, we need to look at each circumstance and decide. And in the context of a US US listing, the situation is different because the underlying work paper for the audit work, which inevitably will involve China-related, information. These information needs to be open to foreign regulators. So that is different, but that issue does not apply to a Hong Kong listing. So my the short answer is that sorry, I'm not very. I don't know exactly. I need to look at the rules, but my preliminary reaction is that the impact should not be very direct or significant.
Thank you. Yeah, that's exactly what I'm asking, because I think that the rule itself does not include listing itself, but I mean, to what extent that listed in Hong Kong would trigger like the cross-border data transfer maybe depends on the company itself, the operation, the business model, or like some industry. So I'm not quite sure like to what extent that it would impact on like a company's choice of listing. Yeah, thank you. Thank you very much.
I think, yeah, as I said, the listing itself shouldn't prompt a need to transfer the business-related data to Hong Kong or to Cayman. So, but overall, I think nowadays all the companies have felt that Hong Kong is a more friendly market for China. Concept stocks. So and data protection could further reinforce that feeling.
Okay, thank you very much. Kitty, would you want to ask your second question, if you are interested, which looks to me it's related to charges and the security?
Yes, it's about like full circulation of the H shares. I think that it's a very like good trend for the Chinese market and Hong Kong market to enforce like the full circulation of the H shares. But the problem is like that I met some realistic problem that the H shares are actually saved in an account of a PRC licensed security dealer. And when the H shares, the shareholder wants to mortgage or pledge the H shares for financing from a Hong Kong lender, then the problem is that whether the Hong Kong lender can automatically enforce the agreement and exercise the power of sales on the H shares when defaults, like when the borrower defaults. Because in Hong Kong, if, for example, the ordinary shares like saved in a Hong Kong licensed security dealer,
I understand your question. I think this is a very this is a very practical question. I as an IPO lawyer, I don't deal with post listing tradings that much. But my first reaction is that once the shares are converted into H shares, they are no longer only Hong Kong qualified brokers can trade in H shares. PRC brokers cannot trade in H shares, so they will not be stored in a securities account of a PRC broker or dealer. But however, whether those
sorry, according to the rule, I mean, now the H shares after the full circulation, it was ultimately registered in the 中国结算中心 rather than 香港结算中心. So like the shareholder actually apply for a special account in a PRC broker rather than a Hong Kong broker. So that's the problem.
You know more about the rules than myself. But I think that's on the side of China, right? And I think on the side of Hong Kong, there should be some arrangement to link the 中国结算中心 with the Hong Kong maybe it's CCAS, because otherwise the H shares cannot be traded in the Hong Kong market.
Yes, I think that trader doesn't have a problem because that they already have a mechanism to connect from the 中国结算中心 with the CCAS. But the problem is like the enforcement. I mean, under PRC law, I think that the PRC broker cannot, for example, enforce agreement like a default situation automatically. Everything should be confirmed like by the court, by a court order or like 法院拍卖. Yeah, it's not like Hong Kong, like the broker can automatically enforce the agreement. So it's like the financing or the liquidity of the H shares, even after full circulation, I still have some like questions on that.
I think those are very good questions, and I have to say I don't have the full answer. I think you're right in that ultimately the H shares are shares in the PRC company, and therefore when it comes to facts affecting shareholders' rights, the PRC company law will come into play, and you cannot only look at the Hong Kong securities regulations. So I think I think you're in that regard, the PRC law could have created a further level of difficulty for shareholders, trying to enforce their rights. But I have to say I haven't looked at this question in that in that detail yet, because this is not an issue that an IPO lawyer needs to think about in most of the cases.
Thank you very much, both, for the question and answer. If anything is helpful here, I see in the chat box we have answer from Judge Wang Fang, who is expert on PRC insolvency law and commercial law. So a few quick points that might be helpful. Let's move on to other questions. I see comment from Charles, but that's not very much related and to our talk. And a question from Li Xiang, which has been to some extent addressed by a link provided by Kitty Zhengxin. Thank you very much. But the question is still about it's a meaningful question about the prospect of full legalization of the VIE structure. So what could happen in the future, given the Chinese government's rather ambiguous attitude toward the VIE. So what is going to happen to VIE in the future? Would you do you have any comments?
Yes, I think this is a very good question too, and I don't think I have the answer, but I can share with you some of the background. So the VIE structure is put in place to enable the foreign company to control a business that is otherwise restricted to foreign investors, right? So by its very nature, even though we don't say it out loud, it is a scheme to avoid the foreign investment restriction, right? It's just that it has been tested. It got the blessing from the regulators, and then it became a model that was replicated in very large scale, and therefore it has become almost a very established practice. What would be the future of the VIE structure? There were in the past 10 years or so, there were several waves of discussions on regulating the VIE. The most important one might be a draft Foreign Investment Act rule that was actually prepared by MOFCOM. And then that draft rule somewhat was leaked into the market, and a lot of people, including the Hong Kong Stock Exchange, saw that. And what that draft rule proposed was that, regardless of VIE, when we decide whether a company is foreign or not, whether the company is a foreign or not, we look through to its ultimate shareholder and see whether there is any foreign investment. So in this case, if the founders are Chinese, then even though this company is a WFOE and therefore under the current regulatory regime is subject to foreign investment limit restriction, when we look through, if here the founders are Chinese, then we deem this company as a domestic company, in which case it can conduct even the restricted part of the business, because we don't view it as foreign invested, and that caused a lot of impact in the market, and as well as the stock exchanges view towards the VIE structure. But if the look-through approach is adopted, then there is no need for VIE structure, right? Because then the WFOE can conduct the restricted business by itself, right? That actually means VIE structure is no longer needed. It will. I don't think anybody will be using a VIE structure anymore. But the draft rule was never promulgated, and what in the end was promulgated a couple of years ago was a Foreign Investment Act that is much shorter than the draft prepared by MOFCOM, in which the look-through idea was not adopted. So the framework of the Foreign Investment Act as promulgated still regulates that, when we look at whether this company is foreign or not, and therefore subject to the restrictions, we look at its direct shareholder. In this case, this WFOE would still be subject to foreign investment restrictions, meaning that the WFOE will not be able to conduct the restricted business directly, and it will have to rely on a VIE structure to do the business. So that was that from a foreign direct investment perspective. And since the VIE structure has been used in so many cases, and some of the companies have grown very, very large and have made significant contribution to the PRC economic and society development, So it's the government would hate to do anything that would affect, the overall economy and overall market, right? So that's why they are taking a very prudent view towards the VIE. And now that with the need of welcoming unicorns to come home, they will have to accept VIE to a certain extent, because otherwise unicorns will never come home. I mean, how can Alibaba or Jingdong come back? I mean, they cannot dismantle their VIE structure, right? Because otherwise they will not be able to do the restricted business. So that's why, the government currently at the moment has sort of taken a compromised approach on the VIE structure. It allows unicorns with a VIE structure to come back on a case-by-case review basis. So what will be the future? Unfortunately, I don't have the crystal ball, so I cannot tell. But I think there are two trends that could help. One is to further shorten the negative list that is currently in place for foreign investments, because the shorter the negative list is, the less need there is for VIE structure. VIE structure is only needed when there is foreign investment restrictions. When there is no foreign investment restrictions, then there is no need for VIE structure. So we can further shorten the negative list, which means further opening up the China market to foreign investments. And the second is probably just to, I think that's probably the only way to go. I mean, you shorten the list, and then you have only a handful of cases where there is still foreign investment restrictions, and in those cases, in those very short list of industries, will the PRC government tolerate the existence of the VIE structure? I think we need to wait and see.
Okay, thanks.
Yeah.
That's wonderful. I actually have I can see there are two quick questions about VIE. One is from Professor Huang Hui from the Chinese University of Hong Kong, Faculty of Law, and also a leading corporate scholar in Hong Kong. And his question is about, I don't know whether empirically that's true. He said most red chip companies have chosen to dismantle VIE even though they could keep it. What's the reason? And the second question is, let me also ask a second question so you can answer both of them. The second question from Wang Fang, that's that's probably the oldest question about VIE. So VIE was actually initially designed as an instrument, as a mechanism to circumvent the law, the regulation. So there was some degree of legality issue in the very beginning. So it's basically the old question about the legality of the VIE. So would you quickly address these two questions?
Yeah, sure. Yes, I think, as a lawyer, one most important thing that I've learned is that there are business needs, and the law needs to evolve to satisfy the business, to address the business needs. I mean, there are needs for companies to grow, and that is actually beneficial to the society, to the country, to the people, right? So the laws need to respect those needs, and that is what has happened, in the past 2 or 3 decades, where the VIE structure has been used. I think the PRC government has been very smart in endorsing this kind of a structure, because look what this has brought to. I mean, Alibaba Alibaba was nothing 15 years ago, right? And because of the red chip, because the red chip companies can list overseas without approval, and because they can adopt a VIE structure, they've achieved significant growth that has changed everybody's life these days. So our firm Haiwen actually participated in the first deal where a VIE structure was adopted, which was SINA. And VIE structure was also called 新浪架构. So because Sina was the first company that ever adopted this structure, and at that point in time, consultation was made with the regulator, with MIIT, the Ministry of the Telecom industry, and they gave their unofficial blessing to this structure, and I think that was a very smart way to do, right? Because otherwise, Sina was not qualified to list in Asia market, right? Because it did not satisfy all the profitability requirements, etc. And Sina was doing a great job, and by allowing the Sina to list over in the US with the VIE structure, it enables this company to continue to grow and do great things to the PRC consumers and to the PRC market, right? So that's why, and in terms of, I mean, you may say that it is a scheme to circumvent the regulation, but does this circumvention cause any harm to the state interest? Right, and I think our regulators thought about everything, and they gave their blessing for Sina to use this structure and list overseas, and that's what opened the door for the whole VIE structure, because everybody else was just a follower, and the VIE structure is very much concentrated in the internet and high technology sector, and the reason was pretty much the same, which is foreign companies cannot own more than 50% in a company that requires an ICT license. So yes, yes, I agree that it is a structure to bypass the regulation, but then first of all, it has the applicants or the underwriters, or all the players in the IPO have respected the views of the regulators. So that's how that's where how we come to where we are today, right? I mean, it is a bypass. It is a bypass of the regulation, but then it enables the company, the economy to grow, and it just leaves the issue for people to resolve in the future, right? And I'm sure with the wisdom of the PRC people and society, I'm sure there will be a good resolution to this issue in the future.
Okay, I don't see any other questions in the chat box. So in case, are there questions from the floor? Anybody wants to ask more questions? We still have a few minutes.
Okay, John,
okay, so you revealed your true face.
Again, thank you for the fascinating talk, because I work from home today. So not just a problem, but because you are all close friends. So I don't think I hope you don't mind. I asked the question in the chat box. As you mentioned, the red chip companies can get listed in the mainland market without the need to scrap its VIE structure. So they can just list it as a VIE or just as a foreign company. But in practice, because I have been looking at this issue for a couple of years, actually, and currently actually writing a paper on this, I looked at the cases of VIE homecoming, and I find majority of them have chosen to dismantle VIE, even though in theory, under the rule, they could keep it. So I just wonder why, and I would appreciate any practical perspective on this, because in theory, they can simply do this without doing anything.
Yeah,
but
understood. Yeah. Yes, I think, for a company with this structure, for a red chip company, to return to the Asia market, there are two ways that they can do. One is they can dismantle the red chip structure altogether, so that they get rid of this part, and the founders, which are Chinese persons anyway, own their shares directly in the WFOE. And then they become a normal Chinese company owned by Chinese people doing a listing in China. This is the typical way to do, especially before the government officially opened the door to unicorns. Before the government officially opened the door to unicorns, as I said just before, companies incorporated outside China cannot list at all in China. So this red chips with this kind of structure can list in China only about 2 or 3 years ago. I think starting in 2018, when the PRC when the State Council issued a special rule asking the unicorns to come back. But even after the door is officially opened, with respect to VIE, the rule still says that it's subject to consultation with the industry regulators on a case-by-case basis. And you don't want to have case-by-case regulatory procedure in China, because that means uncertainty. That means no clear channel. I mean, it's not like a standard operation where you just file documents and then you get approved. It's not. It's case-by-case, indicating that the regulators will have discretion in whether or not to approve it. And as of now, there are very few. I think, last time I checked, there is only one company which has completed listing, which is the 9号机器人, the 9bot company. And, the process of 9bot IPO was very, very long. It was one of the longest, IPO in China. So that indicates that, within the VIE structure, it still adds further uncertainty to the IPO process. So that's why I think, where it is possible, they can, the founders can choose to dismantle the whole red chip structure and list as a normal domestic company. That would get rid of a lot of the uncertainties.
Okay, that makes sense. So it's a case-by-case approval. So yes, you are right. So far, only this company got the blessing from the regulator there, because that's the only company got listed with VIE. Yeah. All other companies dismantled. So probably that's the reason is because they failed to get approval from the regulator, right?
Or maybe they tried, too early. I mean, they already dismantled the red chip structure before this door was opened, and also the door is only open to certain qualified unicorns. Not everybody can list, right? Yeah, I mean, it's a narrow door.
Thank you.
Yeah, no problem.
Thank you very much. Thank you very much. I do have a lot of questions, but I would, given the time limit, I would ask some very, very simple, curious questions. The first question is, when the red chip companies coming back to get listed in the PRC market in China, you said they can issue A shares, but what's the legal basis? They are foreign companies, right?
Exactly. I think there is no legal basis.
I was curious about it. I was thinking whether I missed anything.
The only legal basis is that it doesn't. Well, let's say it doesn't violate any written rule, right? Because Asia is just a term that people use. I mean, there is no definition of A share, right? I mean,
so we cannot find anything in the company law and the security.
Right, there's nothing in the company law. Exactly, and also the company law doesn't apply to these companies anyway, right? The PRC company law doesn't apply to the red chips.
So there's no assumption that the A shares market are only for domestic issuers.
But there is some. It's not spelled out in the securities law, but if you look at the securities law, it was drafted with only Chinese companies in mind, because from places to places, it refers to the company law. Right, and company law, of course, means the PRC company
registered.
law.
Yes, yeah, registered. Registered in
Mm.
China. Yeah, because I was thinking so there's no such a prohibition. That might be the legal basis, right? The negative
Yes.
basis. It reminds me of the dual class share, because Chinese company law and the securities law don't prohibit the establishment of dual class shares. It only says that shares in the same class should carry the same vote, right? But doesn't prohibit companies from establishing second class of shares. But in practice, either because no company has ever tried to do that, or because the CSRC never approved any such request.
It's now it's allowed. Now it's allowed in the
preference shares, preference shares, but still not the A share, B share stuff.
Yes, A share, B share is allowed in.
Sorry, and not the Chinese concept of A share, B shares. So, for example, in the American concept, A share, B shares refers to different classes of shares, and the Chinese A shares and B shares, they belong to the same class. They are both the ordinary shares. Yeah, they're both ordinary shares. So forget about this question. I also have another question. So the VIE structure. So the order is you set up a company in Cayman Islands and followed by a subsidiary in the BVI and then Hong Kong. Is there any reason for the order?
I think that's primarily for tax reasons.
Would you elaborate a little?
I don't know the full details. I think this level has to be Hong Kong, because there is a tax treaty between Hong Kong and China that cuts the capital gain tax at this level. And then why there has to be a BVI level, I don't know the full detail. Sorry.
Okay. Yeah. My last question, very much policy related. And you, from your slides, I can see the CSRC response to the SEC requirement regarding a much stronger degree of disclosure. The CSRC response was rather mild, right? Yes. So not very defensive, not very hostile, and actually sounds actually quite mild. Not necessarily cooperative, but very mild. Was there any reason behind it, or is it because the CSRC is becoming more civilized these days?
Well, I think I appreciate the CSRC's response on that day very much. I think it was a very good response. To be fair, the SEC is not doing anything wrong. I mean, if I were the gatekeepers for the US investors, I would do the same thing, right? I mean, look at what happened to Xindongfang overnight. I mean, share the value like 70% or 8% of the value diminished, and that was a huge loss to the investors. I mean, you cannot argue against the SEC chairman, arguing against his requesting of further disclosure. I mean, they're not doing anything more than purely asking for more disclosure. And given what happened in the market and what happened, the PRC policy changes, impact on those China concept companies. I think that was a very reasonable ask. So, yeah.
Good. Thank you very much. Thank you very much. So we are approaching the end of the seminar. Actually, this is the longest seminar I have attended in quite a number of years. The most seminars would last just for 1 hour, maximum 1.5 hours. But we are having a 3-hour seminar. As I can see, I was watching the number of participants. Very few people have left, and I think they are all so much attracted to the presentation itself, and as well as the very dynamic discussions. I think all the participants would agree with me that we had such a wonderful time together. And thank you very much, Lanjie, for your presentation, and to all the commentators for the insights. I would call it a day. Unfortunately, we cannot if without COVID, we would probably be able to treat you with a nice dinner and give you some gift. But because of thanks to COVID, you're doing this for free. And we hope we can create some opportunities in the future to bring you to Hong Kong, where you lived for such a long time, to see our colleagues and the students in person. Thank you very much.
Thank you very much, Jiang Yu. Thanks very much. It was a great pleasure on my part as well. And I enjoy, the conversation and discussion. And also it's very inspiring for me to hear, to look at these issues from a scholar and from an academic perspective, because a lot of times we very much just keep our head buried in the practice, in solving the issues that the clients are facing, and we don't think about the legal basis, the bigger picture legal issues. So this has been a great opportunity for me to learn as well. Thanks very much.
Thank you very much. Thank you very much, everyone. So
okay.
Let's call it a day.
All right. Thanks. Bye-bye.
Bye.
Bye.
Thank you. Bye.
Thanks. Bye.
Thank you. Bye-bye.
Bye.